I'd like to call the buttons up, right? Buttons up. Buttons up. I'd like to call the March 16th Board of Zoning Appeals, Harlem Township to order. Roll call, please.
Steve Eisenbrown,
Here.
Keith Campbell,
Here.
Bill Gallagher,
Here.
Kyle Ferris, Amy Richardson, not here, and then Jim Steelsmith,
Here.
Chris Perning.
Chris is not, he got jammed up. He was trying to make it, but he's not going to make it. Okay, can we stand for the Pledge of Allegiance, please? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Well, as part of the roll call, we also, for the record, I see one Zoom participant right now, which is Mr. Singer, for the record. I would like a motion to approve the agenda with flexibility.
I make a motion, we approve the agenda with flexibility.
I'll second.
Second, all in favor?
Aye.
Aye. Let's take a minute, assuming you guys have read through the minutes to get that knocked out. So the first one is the January 19th organizational meeting. Did anyone have any questions, comments, corrections on that one?
I abstain, I wasn't here.
Okay. Hearing none, do I hear a motion to approve them?
I make a motion, we approve the minutes for January 19th, the organizational meeting.
I second it. All in favor? Aye. Aye, approved. The next one is the January 19th regular meeting minutes. Again, any comments, corrections, input on that one?
Abstain.
That's right, you were on a boat.
I make a motion that we accept the regular meeting minutes for January 19th as approved.
The second, Jim? Second it. Thank you. All in favor?
Aye.
Aye. And the last one is the February 16th regular meeting. Any questions or comments regarding that one?
I didn't see anything wrong with them.
Okay, may I have a motion to approve?
Make a motion, we approve the regular BZA meeting from February 16th, 2026.
I second.
Okay, all in favor? Aye.
Aye.
Aye. Opposed? Nobody's opposing that. Okay. All right. Thank you. Actually, thanks for getting those put out there. It does bring up one order of business before we go into new business here. Is everybody getting the emails, the township emails? Is everybody online?
Nope.
Is there a reason not?
Yeah, I'm
to?
supposed to call,
Carol?
I called him and then he didn't get back to me and I'm lax. I haven't called him back.
Can you do that, please? Try to, yeah, because, we're not supposed to be circulating emails
Oh, on personal. Yeah, I know.
onto personal emails.
I know.
And the personal risk part of the side of that.
Well, I'm not getting anything.
Okay. Are you
No,
connected?
I gotta get with Ashley. She told me she'd help me
Okay,
because I'm illiterate
yeah, well, it's
when it
not,
comes to the computer.
you can
and other
use, if
stuff.
you can use your phone, you can use the website, so, okay.
I'm up and running.
You're up and running. I know Kyle is, and I don't know about Amy. I'll check with Amy. All right, we'll keep clicking along here. So, because just for the audience's purposes, we have a training session scheduled at 7:30 tonight. So we will run through new business up until that point, and then we're gonna break for the training. It's a public training, but then we will rejoin the business if we need to, if we haven't finished up our regular business. And so new applications. We have a carryover application, I believe, coming in tonight from, yes?
Yes.
Okay, you're up.
Thank you.
Thank you.
Thanks.
And I can actually take the rest of your copies. Those going to be filed, you can keep one if you need it for reference.
Yeah.
Yeah, absolutely.
Thank you.
And if you could speak from either the table where the mic is or at the podium, and make sure the red button on that is up.
It is.
Okay, okay. So please identify yourself and the area of interest, please.
Yes, my name is Harlan Young, owner of Center Village Pizza, and I'm applying for a variance for a second sign, given that we're at the northeast portion of the intersection, to be able to have a western and southern facing sign.
Okay, why don't we just take a minute and read through this, guys? And then we can see if there's any questions. At this point, what we're most interested in is making sure we have all the material.
A lot of neighbors.
I'd say. Mike, have you looked at the proposed sign? Does it comply with size and so forth? Okay, I assumed that you had already done that. Okay, so we have the owner of the property here, the business, so we don't need a notarized power of attorney. I see that we have a deed included. Yep. A drawing of the property. Have lots of adjoining neighbors.
going through this exercise, I did notice a lot of neighbors have multiple parcels. So that filled up the form
Okay,
quick.
okay. Does anyone see anything here that we have?
On the front page of the application, we need, yeah. Range and section, I don't know if that's applicable or not, or a subdivision name if applicable. And the total acreage be considered. Proposed use is not. down
You
there.
speak up.
Okay, Keith is saying the proposed. But he's
On
not,
the front page, there's some blanks need to be filled in. We need an applicant's signature too, at least on the original.
do we, okay. So proposed use, a reasonable answer to that might be business sign. Okay. He's got the total acreage in there, total acreage to be considered. I guess it would be the same amount. It would be the 0.2. I don't know what range is. Do you, boss?
Yeah, I don't know, it's on the map usually that. I'm looking here at the auditor's site and I can't really see it there either, so. It might be show up on the deed, I don't know. And in the current zoning district, and the current usage just needs to be filled out too.
Yeah. So do you know what that,
You know what district that is? Is that a C1 or something? Like
can you do that so we can? The other content, I believe, is here. Do you agree?
What
For the application?
yeah, everything else looks.
Okay, so here's what I would propose. We'll give these back to you, and if you want to just work from a chair or something.
Sure.
And sign them all and give them back to Ashley. Fill in the blank here on proposed use, total acreage, and then C2.
Business sign.
C-2.
Okay.
And
Something in
just, huh?
You want something in section,
I don't know if it has one.
the section and range shouldn't be applicable.
Yeah, I think it's because it's such a small amount of land. I don't think
So given that we're going to accept it here in a minute, so we can conclude this discussion. Our next meeting,
I'm gonna correct this and have them.
yes, ma'am.
Say, did you get a saying about current use,
I
the
put
same.
business sign.
current and for proposed and current? Okay,
Yeah.
put business signs too.
And do that same thing on all this?
Thank you.
They will just-
So our next meeting is on
I
the
was gonna do
20th,
off a few and we'll push the sheet out,
Just-
20th of April.
just the original copy, yeah.
Would you like to?
You're gonna put.
Uh,
copies on.
Oh, I
Actually,
see.
why don't we set a hearing on the 20th of April for 7:15 that day. Does that work for you, Harlan?
Yes, sir.
Okay, All right, so if you tidy that up, we'll accept the application and we'll see you on the 20th.
Thank you very much.
Okay.
After I fill that out, should I just leave?
Just give it.
Yeah, just leave them there and I'll give them all back and
Thank you very much.
I'll get it for you.
All right. Do we have any other new business or applications this evening? Okay. When Harlan moves, we'll let you take a seat at the table there. Would you identify yourself and
Yeah.
your interest?
Good evening, everyone. So my name is Attorney Scott Messer. SCOTTMESSER. And I'm here representing Mario Capaccia, the owner of 12039 Center Village Road. And I'm hoping to make application, but Mr. Capaccia couldn't be here tonight because he has the flu today. I do have a signed application that he has completed, but the only thing that's missing that I wanted to ask the board about is I've searched everything from title companies to owners to the county itself, and there is no current existing survey stamped by a surveyor. This is basically a substitution of non-conforming use application. There's no new development. There's nothing new being proposed. So I just wasn't sure if the absence of a signed current expensive, unfortunately, survey would be absolutely critical to this application. If so, we'll have to, I do have a surveyor that we could use, but it's an expensive process and would take a little bit of time.
We could use what comes off the GIS, couldn't we?
Well, normally when you get a property deed, it has a survey attached with it.
Right.
There is a legal description on the deed as well as a architect rendered site plan that shows boundaries, everything that you
You
would.
have a copy of the,
I do.
see what you have, see what would.
Thanks.
Yep. Mhm. The original.
Yeah, I'll just grab it from me at the end.
Okay. Well, in the past, for the purpose of a survey, have we not accepted
Everyone I've had it drawn out
had a,
and, in fact,
It has to be drawn out,
and
and the location of the building has to be
be shown on that property?
shown on it and any other buildings.
Yeah.
Easements,
with the front, rear side setbacks of all
Yeah.
the buildings where they are located on the properties. And
Most of that is shown on the site plan, but it's not painted by a surveyor. The site plan has all the location of the buildings. It has all the setbacks. All the easements are listed on there.
didn't see it.
Just the,
Okay.
Yeah,
So where this? Is this the shape of the property there?
It is.
Well, basically, that is a survey. It's not
It's just not stamped.
stamped.
Right.
That's correct.
exactly, yeah.
I wonder where these people got this. This to draw it up from. They had to have those dimensions and locations and something.
Well, this is dated 7/21/24. This site plan. Well, we need something from the county that validates this document, I guess, I mean, that shows at least the boundary dimensions. And then from now, we could use this, I think, to accept that the placement of the building and so forth is acceptable. But
Up here. The GIS map looks like.
um,
Did a engineer or an architect draw this?
Yep.
Get him to stamp it?
I could get him to stamp it.
Will that suffice?
I think so.
Yep.
Yeah,
There you go.
Yeah, if you would accept that, he would have no,
Well, he'll stamp it with today's date or whenever he does it.
he will stamp it with
Yeah,
today's
and
date.
that way we know it's correct.
is it,
Because we will be referring to the buildings and stuff. No, they're correct. Yeah.
There's more than one parcel.
Weird.
Yeah, you can see from the county, how it's kind of tucked in there. Parcel, all those parcels are very long and narrow.
Does that suffice with you guys to get the,
yeah, I think
Surveyor
that'll
or
meet that. I
engineer
think
to-
you'll have to bring that back
yeah, he'll have to
Can do
bring that
that.
back, but
in April, and then we can accept the application at that point in time. For the purpose of receiving the application, does anyone see anything else here that, so we don't have to ask them to come back and yet again, you want to take a minute to look? I see we have a deed.
Yeah. No, I'm not through going.
Go ahead. Okay. You guys, what? So in order to accept an application without the owner present, we need a power of attorney from him.
I would expect since we're gonna have to come back in April and make the.
So are you okay with coming
I'll either-
back in
yeah.
April
I'll bring this back stamped
and and submit it
and everything to all of you.
and make application then?
And either he'll come with me or I'll have a notarized power of
Okay.
attorney.
Okay, then we'll return these.
Is there anything else? I mean, I'm happy to entertain any other. I'd
Other
like
than
to
that,
be,
it's pretty much complete.
yeah, I'd like to make sure that we can get it
No,
applied.
no, that's why I'm trying to make sure we don't have to do this twice for you. Okay,
You.
thank you. All right. We'll see you in April.
April 20th is the next.
Correct.
meeting, is that Correct.
Right.
Thank you.
For you.
Yep. It's Mike. I'll fix it.
Mike, did you get the other one? You got the other guys all corrected, right?
Yeah, she's already got
I
it.
have copies. I'll give to you guys at the end.
Whatever.
All right.
I
Okay,
Make a motion, we go to training.
very good.
On deck.
Pete, you're up.
How long you guys want to talk?
I don't know. This is a dangerous group. So if you would,
It's on
you
now.
would identify yourself, please.
My name is Pete Griggs. I am with the law firm of Brocious, Johnson and Griggs. And I serve as outside counsel to the township. So I think you're having me here tonight to do some training for you guys. So I did send Mike over a training packet. I'm not going to go word for word through that. Most of it is legalese in the beginning, and it's just kind of high level stuff. If you ever have any questions, let me know. How do you guys want to do this? Do you want to ask me questions? Do you want me to kind of go through?
I think if you could just go through your overview here, step by step thing.
Yeah,
If we have a question, we can stop and ask it then.
sure.
That way-
So generally, so most of the stuff that's in the beginning is, I typically skip, and I start with kind of your function. And whenever I do these trainings, whether it's trustees or zoning commission or BZA, I always want the client to remember one thing, and that's really their role in the scheme of zoning. What is their role? And for you guys, as a board of zoning appeals, it's really easy. I mean, you essentially have one role, and you are the judges, right? So you serve in a quasi judicial capacity. You're a quasi judicial board under Ohio law. So your job is to hear the facts and apply the law. Whereas the zoning commission and the trustee, oftentimes, they're involved in the legislative process in terms of actually coming up with the text and rezoning property. Those are all legislative functions. So sometimes they can also serve an administrative role, but your sole job is to act like judges under zoning. So that makes it easy for you guys. The bad news is you are the body that will more than likely get the township sued.
Yep.
Yeah, it's just the way it works, right? And it's not because you don't know what you're doing. It's because that's the way the system is set up. So as you guys know, when you make a decision, whether it's on a variance or a conditional use application or making a decision on appeal, your decisions are subject to direct appeal to the Court of Common Pleas within 30 days. So it's more of not because you are doing something wrong. It's just that's the way the statute's designed to work. So, but serving in a quasi judicial role kind of tells me four things. One, as I just stated, your decisions are subject to appeal. When the trustees rezone property or do a text amendment, the remedy is referendum,
Random,
right? So the second thing it tells me is my communications as a board member. No ex parte communications with an applicant. So that means that your communications with an applicant should be confined to the record. Trustees, once again, different. So if I come in and I want to rezone property to a PD or to any district, and I want to have a conversation with one of the trustees outside of the hearing, that's permissible under the law. There's nothing wrong with that. Some people may have a philosophical problem, but legally, I always kid people, like the big developments that go through, there's a small select group of land use attorneys, and they typically know the vote before before the good ones do anyway, typically know what the vote's going to be before most trustees ever make a decision. So appeal, no ex parte communication. It also tells me how I have to run my hearings. So I typically tell people that you should run your hearings like a civil trial. And we'll talk a little bit about some of those finer details. The trustees, when they're rezoning property, I always get a kick out of, residents that show up and the board of trustees swears people in during a rezoning hearing. And, I think to myself, when I take that oath as a resident, I'm telling the truth, the whole truth, no, so help me God. And you think about in a rezoning, what people typically talk about, it's not the truth. It's the furthest thing from it, right? It's pure speculation, personal opinion. And a lot of times you guys get the same thing. And so we're going to talk a little bit about when it gets down to time where somebody is not going to be happy with your decision. Whether it's a next door neighbor that's not going to be happy or whether it's going to be applicant, really kind of honing in on what a reliable evidence as opposed to speculation and personal opinion. The other thing that tells me, lastly, is, I'm assuming you know this, but I'm going to tell it to you anyway, that I have the ability to deliberate an application in private.
Yeah, I saw that, and I guess I have seen maybe one other time, but the way my time on the board has been last kind of 3 years or so. And first of all, we haven't had that many applications. But I've always felt uncomfortable a little bit that, when we came to, okay, and I like the agenda. I actually read through this a bit this afternoon.
Great. Appreciate it.
The agenda for the hearing is, just good boilerplate material. So what you're saying is once we have heard from the applicant, we have heard from the zoning inspector, we have heard from relevant citizens, residents who want to make a comment, we have the ability to go into
private deliberations.
Discussion.
Yep. So it is a case so you won't find that in zoning law, in the Higher Revised Code 519. It doesn't exist. But what it is, it's basically case law born by the Supreme Court that says that any quasi judicial body in the state of Ohio has the ability to deliberate the merits of an application in private. For your purposes, the first time that issue was challenged, um, under a BZA's authority was actually Liberty Township here in Delaware County. And it actually got appealed up to the Fifth District Court of Appeals, and Fifth District Court of Appeals says, yes, Board of Zoning Appeals, Township's Board of Zoning Appeals are quasi judicial bodies. They have the ability to go back, privately deliberate, as long as they come out of deliberations and make their decision on the record. They're entitled to do that.
So what I read was, it really is just the board that can come together in that case. We would
Yeah.
not bring the zoning inspector
No,
into that meeting, but we
Nope.
could bring the prosecutor.
correct. So any legal prosecutor, most definitely. I absolutely bring your legal counsel back there with you. I've actually had one time where the board didn't want me to go back with them, and I'm like, oh, okay.
Self out.
Yeah, go right ahead. My job is to help you craft your decision.
Yeah.
And that's essentially what you're doing. So it's as simple as a motion to recess the hearing for purposes of discussing the application or the merits of the application in private.
I like that. I can think of at least
could've
one
used that.
instance.
And you only do it when it's necessary,
Mention
right?
Which one, but I can think of one where, because none of us are lawyers. And most, even though, well, we have a few, longstanding members, but so we're not that deep in this stuff.
Yeah.
And so it would be beneficial to maybe have some discussion like that.
Yeah.
For the purpose of education and forming a, decision-making process.
And there may be
I like
times,
that.
yeah. And so sometimes it's a matter of just walking through the issues and talking amongst yourselves and seeing if there's any more questions you need to ask of anybody. Also kind of outlining how you're going to render your decision is sometimes beneficial as well.
Yes.
But on the record, when you come out on the record, going through everything, I've found it beneficial when I know. So I'd probably say 99% of the time you don't need to do it. But when you have a room full of people, or you have everybody is, I had a case in a Southern Delaware county township that the BZA had legal counsel. I represented, which was the prosecutor's office. I represented the zoning inspector. It was an appeal. The next door neighbor had an attorney, the property owner had an attorney, and the HOA had an attorney. And yeah,
Wow.
it was crazy. In that case, I went up to the Court of Appeals, but once again, it's cases like that where it's beneficial to just take a deep breath, and be able to talk without people yelling and screaming at you.
Well, it helps you then get your thought structure in place
Mhm.
to come back in and look a little bit more on point when you want to deliver the basis of and then the decision that you've
Yep.
made.
Yep.
No, that was worth this already for me.
So, and you are correct.
Okay.
You are correct. Don't bring the zoning inspector back with you. I've had some townships that we've not been there and they've done that, and then their decision gets appealed and we're representing them on appeal. And the zoning inspector is an adverse party. So
Zoning inspector, that tends to be kind of like the prosecutor to some.
correct,
Right?
correct. So we don't want anybody making an argument that the zoning inspector back in private deliberations bias the
Right.
board. So,
Yeah.
I've been on this for over 25 years.
Yeah.
It's been a long time. And I think only twice we went back.
Yeah.
Executive session with the attorney to get advice, or
Mhm.
legal counsel. We only had one that ever went to Court of Appeals. And in that process, it took so long that the people gave up and they moved out of the
Yeah.
township, went somewhere else and under.
Yeah.
So, but yeah, but we've not had too many
Yeah,
really tough ones. I think we've been lucky at
not yet.
that. Yeah, but it's getting.
It's going to get worse.
A lot busier now than it has been.
Right. And so you mentioned the words executive session.
But that's.
Yeah, don't call it that.
The deliberation in it.
It's private deliberations and, you know, I've had clients where we haven't been there and it's been on appeal and they use the word executive session. Thankfully, the judges say, look, this board they're a bunch of lay people.
Amateurs.
Yeah. I mean, but it just gives,
What's the difference?
an executive session is a statutory right.
Yeah.
And there are 8 reasons where you can go into an executive session. This is not that.
But what
That's
we-
a statute.
What we do is we recess the hearing.
Yeah.
correct?
So, executive session has to be under 121-22 G 1 through 8, and you have to state the specific purpose of and state the section, which never applies in the BZA.
Right.
It's private deliberations.
Yeah.
But yeah, so, you know, that's a helpful tool, and I don't disagree with you at all. I would only use it when it's absolutely necessary. But it's nice to know that it's there if you need it.
But so for Ashley.
Private
Go ahead.
deliberations, we need to, how do we announce that to
Motion?
make a motion to?
Yeah, second in a vote. So it's a motion to recess into private deliberations for the purposes of discussing the merits of the application.
So the technical term is recess,
Correct.
and it takes a
I want
motion.
to make sure we use the right term.
No,
Yeah.
that's right. Well, that's why I wanted Ashley to be on, because she helps us.
Yep.
Keep ourselves out of trouble.
Yep. So, and what I would say is, you know, at the trustee, you know, kind of crossing over at the trustee level or the zoning commission level, they don't have the same right because they're not a quasi judicial body. And those 8 reasons for executive session are never going to apply to them during a rezoning or a text amendment process. So they have to have all their deliberations on the record in front of everybody
Right.
because it's a legislative process.
Okay.
So just understanding, you know, kind of that role. Do you guys have rules of procedure that you've adopted?
Yeah, somewhere.
Do you do? Yeah. So you guys have an organizational meeting every year?
Yes.
Yeah. So you should just be reaffirming your rules of procedure.
Well, that's the Robert's Rules of Order, right?
We have that, but we have the other part. I didn't bring
I
all my
don't
stuff
have
with me
that
tonight.
with me.
I didn't either. I didn't think I needed.
Yeah, that's fine. I mean, I'm quite frankly,
Where is that located? I mean, where's that documented?
you should have that with you every meeting.
I don't know. I just keep it in my briefcase. I bring it in.
Do you know where it is?
I can print it. It's on the other computer, but.
So I would stick it in your
Building. my
zoning code,
notebook.
your zoning resolution binder that you bring.
So would you
Just stick
send
'em in
me a
there.
Copy of that, please?
Yeah. I'll see what I have and see what she has.
It's just good to have, just in case somebody like me shows up and
Yeah.
asks questions and you're able to have them. But you're ahead of the curve because be surprised how many people don't have them.
Okay.
And be careful with saying we're going to follow Robert's Rules of Order. Because quite frankly, I'm not sure I understand all of Robert's Rules of Order. I mean, you ever seen the size of Robert's Rules of Order?
Yeah,
The
I
true,
mean, it is, yeah, I think the wording somewhere is, you know, the intent is to follow known processes such
Yeah.
as you know, so it communicates, there's, you know, a structure.
yeah.
It's not, we're not committed to it.
I mean, I got a book in my office like that thick of Robert's Rules of Order, but I mean, for the most part, it's the seconding of the motion, the roll calls, understanding the difference between the continuance and the tabling and that type of thing is really all you really need to know.
Okay.
So, that's really kind of, your role. You guys are videoing online. Do you guys ever use a court reporter at all?
Yes, yeah.
Okay.
Yeah, we've had a couple instances in the last couple of years where we have.
I normally look at that as an application when it comes in and there's a bunch of people that seem to have responded. Then we think we might need a court reporter. We'll probably.
That's perfect. Yep.
Most of our stuff is
Pretty simple.
Yeah,
rubber stamp almost, you know what I'm saying?
we don't need it like on tonight when we're taking applications, there's nothing contentious because we're really not debating anything. But if there was an appeal, or if we made a decision and then that led to an appeal, but what would it, what, here, so when we got into the one previous to the application we heard tonight, that was where they appealed your decision, right, Mike?
Yes.
And so we had a hearing on the appeal.
Hmm.
And in that instance, we had a court reporter.
Okay, that's fine. Yep, perfect.
So,
Didn't you have it during the hearing itself? Did we bring it back?
yes,
Yeah.
Yeah.
It's interesting what you did tonight. I've also been doing this for about 26 years. I've never seen what you guys did tonight.
did we do okay?
You did fine.
When you hear that preamble, it's like, I've never seen one like that.
But quite frankly, I've never seen a BZA review like the application before it's filed. I'd probably say almost all of our clients they determine whether or not it's sufficient or not, and then they let you know, and then you schedule, then the hearings.
So now, see, that's different.
That's the question I was gonna ask you.
Yeah, that's the.
That's
County
never-
prosecutor.
That's very interesting.
That's fine. I mean, I'm not your statutory prosecutor, but I've never seen, I've never seen that before.
Mike was just recently told it's not his role to coach an applicant through the application process and to review the application in advance to ensure it's complete.
The only thing I'm allowed to do and it's really the last prosecuting attorney we had and the new one I just got said, the only thing I'm allowed to do
That's
is.
Vince. Okay.
And Corey was the last one. They said, this is the two things I can do. You can take that checklist and say, do you have a survey? Yes, check. You have this? Yes. I can check it off and I can check it for legibility. I'm not allowed to give it. They ask me a question like, I don't understand what this is. I'm not allowed to.
Well, I don't necessarily disagree with that, but if their application is incomplete,
Well, and that's it. That's.
so if you're going down through your checklist
And they say they have it.
and I haven't provided, let's use a survey. Let's say we have to have a survey. And I come in and I file the application and I say, you don't have a survey. You mean to tell me that the prosecutor's office says that you can't tell them that?
Yeah.
Huh.
This statement is I'm not supposed to tell them,
Okay.
answer any questions or tell them what they want. And I agree with you. I think I should be able to look down there and say.
Look, I mean, so follow their advice.
I think we need to.
I'm not sure that I've ever seen that, and I'd probably say that 99%. And I'm not sure that, look, I'll ask some of our other clients, but I'm not sure that our other clients have in this county are doing what you guys did tonight.
So we use it as to ensure completeness
Yeah.
so that that we accept it. And if it's not complete, like we did last
Yeah.
time with the pizza guy.
It's
we
not
went
wrong.
Back and got the rest of the material required. And tonight he was complete and we accepted it and everything.
I think it gives us a chance. I like what we do. I know what you're
It
saying.
also gives us a chance to get the engine turning over a little bit with what's coming at us. So,
But when he had no survey, but it was a survey and nobody had guaranteed it.
Yeah.
Because in the state of Ohio, an architect or an engineer is guaranteeing that that's correct.
Sure.
Yeah, and they're licensed and all
Yeah.
that. So the chance of being able to keep him from spending more money, I said, well, the guy that drew this, is he,
Yeah.
And so that was a good outcome.
No, so there's nothing wrong. I've just never seen it. I mean, but there's nothing wrong with it. I mean, but
Known it for a long time.
yeah. I'm just saying, like, I'd probably say everybody that those issues are handled at a staff level, but that's fine. I just was kind of, I'll be honest with you, when they started, I had no idea what you guys were doing. I'm like, well, crap, they're not swearing anybody in. And then it dawned upon me that that's like a pre-application meeting.
Just to clarify, if they come in there and I say, do you have a survey? They say, no, I do tell them. But
Yeah.
you need to have everything that this list
Yeah.
says you need to have.
But a lot of times
That I do tell them, but I
they'll
can't
tell
look at it
Mike,
and say, that's not what they're looking for.
Yeah.
That's not what they're looking
Yeah,
for.
no, look, so
but a
keep
lot of
doing
times
what you're
they
doing.
have everything and they don't.
Right. Right. So, but no, I just was
Okay, that's
kind of
interesting.
fast.
To
So,
make this,
But it's nice to know we're different.
well, and we're trying to make the application process efficient and not contentious to at least get the application placed.
Mhm.
Right? We can get contentious later, but.
Yeah, yeah.
But,
no, it's fine. And I would just say, and you guys did fine tonight. I mean, I think the only drawback is potentially would be, and like I said, you guys stuck to your script, potentially gaining evidence outside the hearing context or discussing.
We have a list.
Yeah, I understand. So the only drawback that I see is that potential. You didn't do it tonight.
right. Well, and I mean, it would have, and I guess alert to that. I mean, as the the lawyer presented us that application, there was a dialogue kind of explaining what's going on and the basis of why he believes, he should be allowed to do this based on another decision recently made. We weren't going there tonight.
Yeah.
Right? I mean, that's not what the purpose is, really just to ensure the application is complete.
Mhm.
And
Yeah.
so,
Yep.
okay.
So yeah, like I said, you guys are happy with it, by all means, have at it.
Okay.
So, jurisdiction, 4 areas, appeal, variances. I don't think we're granting any conditional use permits for mineral extraction.
Right now.
Never had one since I've been here.
Yeah, and then conditional uses. So you guys know appeals typically happen when staff makes a determination pretty much on anything, whether it's a zoning violation, whether it's a denial or approval of permit or an interpretational issue. And that appeal can be taken by any quote unquote aggrieved party. That term is not defined under the law, but it is definitely the applicant, property owner, and contiguous and adjacent property owners are always going to be an aggrieved party. Once you get outside of that, it's debatable. You have to show, if you're outside of that footprint, you have to show special harm. And it gets really difficult to do. So
Saying a guy that lives 2 miles down the road.
has no ability to appeal, to challenge, to appeal the zoning inspector's decision.
That's interesting.
That's what happened.
Unless they show special harm. And my guess is it's going to be hard pressed.
That's
I've
what
won more cases on that than
The
anything.
dog triage place we
Mhm.
did, okay? That's been 5 years ago, more, I don't know.
Yeah.
A time ago. We give them the okay to do what they was doing, and dogs were kind of a gray area anyways, because that's almost agriculture. Since that time, it's been brought up as being agriculture. And someone filed an appeal to the Court of Appeals about our decision. Took almost a year before the court got to it. And then their finding was that he lived too far away from it and he was not an aggrieved party.
Interesting.
Had no,
Yeah.
had no
Well, I understand it on the,
Just what Pete
on,
was saying.
but if, to the point of Mike makes a decision and somebody way far away doesn't like it because they drive by it or whatever. That's interesting, yeah.
Yeah. So, and,
So how close do they have to be?
so it's going to be, obviously, if I'm the applicant or the property owner, or I'm contiguous or adjacent.
Probably the people.
That's the only
The
one.
people on the list.
The other thing I typically tell people is under the law, the notification provisions is that footprint.
Okay.
When you add to that footprint by having a distance requirement, say within 200, 300, 400 feet, I think arguably you're giving somebody the ability to make an argument that they're an aggrieved party. Because why else would you send me notice? Right? So contiguous or adjacent,
Mhm.
that's also the area that you're required to give notices to of hearings on applications. Now, if you have expanded upon that by saying 300 feet from the property, which is more than,
I thought that,
We do 200.
We do 200, but if we
That-
shouldn't do that, then we should just say,
that's written in the statute.
Yeah, I was gonna say, that's in the,
It's written in Ohio law.
it is?
Yes.
200-foot buffer.
Oh, I didn't know that.
For the BZA,
maybe.
now for the zoning commission, it's not. But
200 feet.
yeah, it's written in the statute.
Huh. Interesting.
I've been there before.
Yeah,
Would cut it back.
Yeah, so let's go back to contiguous.
No, so
Now, the BZA's definition and the zoning commissions are just different because the 200 feet is on ours. Theirs just says adjacent and contiguous. That's, that's all.
Does it say that?
And 519.
So the ORC?
yeah, well so that's news to me. When I read 519, I don't see it in there.
Pretty sure.
So, I mean, first of all, aggrieved party's not even,
Anything other
Fine.
than we've just expanded our aggrieved area.
yeah, no,
Ours has been the same forever. I mean,
Yeah.
that's been
Yeah.
like 200
But we haven't heard anything other than what you're
so
saying.
that distance requirement, I've seen it anywhere from contiguous and adjacent property owners to all the way up to 1,000 feet. Point being is that when you send the notice to somebody, that is more than likely who's going to have standing to appeal the decision.
Okay,
Okay?
yeah.
that's good.
Because aggrieved party is not defined in the statute. You're required to give, and the statute uses the words, you're required to give notice to the quote unquote parties in interest. And that term's not defined in the statute. So, the other thing too is I think your code, have you updated your code on the new laws with respect to, publication is no longer required?
Yeah.
You guys have done that?
Yeah.
Okay. Okay. Okay.
Actually, it's
That was all on the day it happened.
Yeah.
But back to the aggrieved parties, so we know who we're notifying, we know that we're following the rules as we want to use them as far as notification
Yep.
goes. So then in the time of the hearing, we have, at the beginning, we swear in anyone who cares to make a comment from the public beyond the applicant and their lawyer or whoever. Are the people who are within that boundary area, are they the only ones that really have standing to make public comment?
Legally, yes.
I mean, we don't want to be rude and tell
Politically,
somebody-
you're exactly right.
Yeah.
So I've been and this applies across the board, whether it's conditional use variance or an appeal. Legally, the only people that have a right to testify are those that have standing to appeal your decision. And I've had attorneys, the real good attorneys, will object to the guy that's 2 miles down the road.
Yeah.
It's not relevant. Now,
To the point of preventing that person from even making comment at the meeting.
most of my clients will acknowledge the objection and let the individual talk. What I would tell you is that when you render your decision, don't be basing it on the guy that lives 2 miles down the road.
Right.
Right.
Okay.
But that's an excellent point. So my mentor, Don Brocious, was the chair of the Bexley Board of Zoning Appeals.
Good.
And which was a nightmare. So I used to go and watch him run the meetings, and he always had this contingent of people that showed up for every application. And so would they get up to speak, and he would ask them questions. And then he would say, you don't have standing to appeal this decision. So you're not permitted to speak. Sit down. And that was the only way that they could really get through their meetings, because they, had
They'd go for
20 things on an agenda every night.
I
So
did see your suggestion is, and we've never done it anyways, not to put a time limit to speaking. That if someone wants to get up and kind of rattle on, I guess, and they have standing, let them go. That I guess it's their right. I know in other township events, we try to use the 3-minute rule
yeah,
for public comment.
yeah. So during your hearing, you should not, the same rule applies. So if I'm a contiguous or adjacent property owner, or I'm the applicant, you should never put a time limit on me. And the reason why is because if I don't do certain things as a BZA, procedurally, then if my decision is appealed, that person can ask the court to open up the record on appeal, and provide additional testimony on appeal at the Court of Common Pleas. If you do everything right, whoever appeals your decision, the judge is confined to the record that you've created.
Okay.
So that is why. So that's appeals, conditional uses, uses that are not permitted, but maybe you guys know, just because they may have potential impacts on the surrounding territory. Variances, two types of variances: a use variance, which quite frankly, I'm not sure I've ever seen a legitimate case made for a use variance. And an area variance. So understanding two different standards. Area variance are the easier ones. That is, and you have it in your code, that's the Duncan v. Middlefield factors. Those 7 factors, those factors are, it's a balancing test. I don't have to meet all of them. And there can be other reasons in addition to those 7. I'm not confined to those 7, but those are the minimum 7 that I have to consider, and I have to consider them because the Supreme Court said I have to. I typically, if I was a BZA member, there's probably 2 that weigh heavily, 2 or 3 that weigh more heavily, and at least in my opinion. One is the variance significant? If I'm getting over 20% in the deviation to the standard, so if it's a 10-foot setback and I'm requesting a variance of 8 feet, that's 80%. That's substantial. So once I get above that 20% threshold, most courts are going to find that to be substantial. Okay, so that's a check mark against. The other factor is will it substantially alter the character in the neighborhood? Right? I think that's another very important factor. Now, you have to be careful. And typically you know, you rely upon neighboring property owners' testimony, I think, to a certain extent, with respect to that, but it's got to be legitimate. Sometimes I think it's hard, to pick up on when it's just they don't like each other. But I think that is very important. In the spirit and intent of the zoning, will the spirit and intent of the zoning resolution be filed? I think is also kind of important in my opinion. Using the setback issue, what is the reason we have setbacks? Right? I mean, it's typically a health and safety issue, at least from my perspective, it is. I mean, you don't want structures being too close to each other. But those are kind of the ones that I see as being important. They're all important and you have to consider all of them, but those are the ones that I think weigh heavily for most of our clients.
I think the alter character of the neighborhood is very difficult
Mhm.
in my mind. I mean,
It is.
it's the character as it existed or the character as it's emerging, as it's changing. Uh,
Let's say like accessory structures,
Right.
I come in here and I'm getting a variance for the size of my accessory structures. And I'm saying, look, my neighbor's got one, they've got one, but mine is quadruple the size as my neighbor's. Right? It's going to stick out like a sore thumb. I think that's essentially what you're looking at, that type of situation. But you're right. I agree with you. It's difficult sometimes.
Gets into, I mean, so that's that's a visual or optical
Yeah.
thing.
Yep.
It could be noise.
Could be.
Or
Yeah.
Light.
Yep.
Right?
Yeah.
Or the combination of some of those.
Mhm.
And people, when you're in a developing area like we are in Harlem Township, where there are people moving here, into trying to turn it into their idea of suburbia versus, rural.
Right.
Uh, there's going to be more and more push of,
Yep.
Is it altering the
Rural character.
historical
Yeah.
character? Or because you aspire to something a little less than, I'm just saying,
Yeah.
I think that one's will be,
Well, I think you're right. I mean, as people,
can be.
people that come from more densely populated areas to the rural areas, I mean, they want that rural lifestyle, but yet they want the same
All the
type of
perks.
services and perks that they had before they left, right? And there's a struggle. There's a struggle there. So weighing those factors, and I don't know how you guys typically do that. Do you guys run through those every single application? Perfect.
Look at them.
Yeah,
Yes.
perfect.
No, we've all got them. and
Yep,
no-
that's great.
Yeah.
Nope, that's perfect.
I haven't run into it yet coming from the building industry. The one I find that's interesting is something that's not the owner's fault.
Well, it's a known or should have known standard.
Well, no, what happens is I look at it as the guy needs a 2-foot variance.
Mhm.
Because there's a giant boulder down there and nobody wants him to blast it. Something like that.
Yeah.
But those are ones that are actually not his fault. You didn't know it till you start digging. And that type of thing.
Yeah, no, I mean, I see what you're saying.
Yeah, if it's a known pre-existing condition and he just wasn't paying attention.
Right.
But one of
I
the
don't have a lot of sympathy.
But one of the factors is, did I purchase my property with knowledge of the zoning restriction?
Yeah.
Right? And more often than not, people are going to say, I didn't know. well,
Well, they always say that.
right, it's known or should have known, right? But again, that's probably, um, you know, that one kind of aligns with can, um, can my request be obviated by something other than a variance? And under the Boulder situation, maybe it can't, it probably can't. Maybe it can't be.
And there's other things in the ground that you don't know. A guy called me over on Red Bank. I think he's talked to you also. And for some reason, it doesn't show. But but he found out he was lucky, but it could have been worse. There's a large gas transmission line through his yard,
Yeah,
and nothing shows. Remember that guy calling?
Yeah, that
Yeah.
was
Yeah.
on Harlem, wasn't it?
Huh?
Was the Harlem one, wasn't it?
Well, no, he's on Red Bank.
This one we had was on Harlem with built the garage.
Yeah.
Couldn't build the
Right.
garage up because
Right.
But
Yeah.
you're right, there is one on, I know it's
Yeah.
almost down
Right.
to,
But I can just see somebody buying that. It's not in the survey. There's nothing there. And all of a sudden he wants to build a house and boom. But there's things that you don't know.
right.
And we haven't had to hit that one yet.
Yeah.
But I always look at that and I'm going, okay, what would cause that? You know,
Yeah, no, and I think that's
everybody says, I didn't know.
right. And I think that's the reason why the list is, you know, there are other things outside those 7 that you can consider.
Mhm.
And that's one of them, right? The other thing, use variance. Have you guys ever had a use variance?
Yes.
Have you granted a use variance before?
Well, they did.
Yes.
What was the reason you granted
It
it?
was very contentious.
It was a situation where before there was zoning in the township, it was one of these, it has always been used for this. And so when zoning went in, it was put on a list of non-conforming,
Okay.
right? And then the property was sold
Mhm.
and the next person wanted to use it, but in a different manner,
Okay.
right? But what they came forward with, and I make sure I get this right, but it wasn't necessarily that they were going to use it for the same use, but there had been a previous use variance,
Okay.
right? And so they were changing what was it? The
substitution of
Subst-
non-conforming use.
substitution of a non-conforming use. Thank you, Mike.
Well, so what I'd argue is that's not a use variance.
Okay.
That's a substitution of a non-conforming use,
We haven't had one since I did.
which the law requires you to do. It requires you to consider that. But
Which is what this well, never mind.
so,
I have a question.
Yeah.
On that same case.
Yep.
Yeah. The aggrieved parties, how much weight should we allow them for their comments? So in the same case, when it came to the end and we all went to vote, none of the other property owners in the area, aggrieved people, stepped forward and said, we're against that.
They didn't know about it.
Well, we informed them, didn't we? Send letters out?
Adjacent or within a 200-foot buffer. That group of people that complained were about quarter-mile down the road. It was those 4 houses down.
Which gets back to the who has standing.
Who's
for
got
that.
standing?
correct.
Nobody
They're-
showed up and I
and-
voted to
Yeah.
let them have the
But at the same time,
Variance.
some of the people that were here and advocating for that didn't have
They
standing.
didn't have
They
standing.
didn't have standing
Right.
either.
Harlem Road.
Yeah.
No, I live over by Hoover and these guys are
Great.
nice guys.
I
Yeah.
mean, that's the hard part. So if I'm a BZA member and nobody bothers to show up for whatever reason, the lack of, I mean, I still think you have to look at the application and consider the merits, but the fact that people have not shown up or not opposing it, I think just intuitively as a BZA member,
I think my hardest part on that one was had wrote up. Obviously hadn't been used. You can take the satellite picture, look at it for 3 or 4, or 5 years and it's all wrote up, but the owner testified that he had been using it. So,
Yeah,
So-
non-conforming
Because,
uses
I
are
was saying
tricky.
it hadn't existed for the last over 2 years, in my view of it, it had been abandoned, the use had been abandoned. But,
Pete, in that case, can you, if they're trying to say, hey, I've been using that as a non-conforming use, can you say, would it be a good call to say, prove it? Bring me receipts? Show me that you were using that as that.
Yeah, so the statute basically says that if a non-conforming use is voluntarily abandoned for a 2-year period,
Right,
it loses its lawful status.
Right.
That under that scenario, then it would be a use variance. But the law also says that my zoning has to provide for the reasonable modification, substitution, or extension of a lawful non-conforming use.
yeah.
To answer your question is the burden of proof is on the applicant.
Okay. Let me
Well,
ask
yeah,
you,
the
if they're
one thing-
expanding, excuse me, Steve.
Go ahead, please.
If they're expanding that use, and this is where we really struggle, and I think we're gonna have another one, is if they're expanding the use. So if a guy was using 3 widgets, there's no doubt that for years and years they were doing so a non-conforming, but the guy comes in and he wants to put 10 widgets operating there.
Yeah.
How do you look at that?
Courts typically favor that.
They favor that?
Yes.
Favor than letting them use the. do the
A
thing.
reasonable expansion.
Reasonable expansion.
Yeah.
Yep.
Okay. While I've got your attention, why we all live in the township
Yep.
to be on the BZA.
Yep.
So we're familiar with a lot of these projects and people and that type of thing.
Yep.
What do you do? I don't know, in your mindset, verbally, when you know they're lying? So again, let's make an example. A guy's got a used car lot. You drive by it every day and there's 20 cars sitting in his yard. So he comes in for maybe a home variance or whatever.
Yeah.
Says he's only got 2,
Yep.
but you drive by it every day and you see 20.
Ask them.
Are you allowed to call him out on that?
Yeah.
Okay.
The other thing you can do is do a site visit.
I was gonna ask you.
Done
that's
that.
On my list, so
Are
going.
we
to-
allowed to go on the site?
Absolutely.
Okay.
You want to know how to do it? You actually come in here first, convene the hearing, and do a site visit together. You get to go on a field trip, right? You go view the site and you come back.
Well,
Now,
so-
do you have to tell them you're coming?
But it's going to be in the hearing context, so I hope they're gonna be here.
oh, you're going, as a hearing, you're.
Oh yeah,
Oh, so,
do it as part of your hearing.
so
He's probably,
they can be here at the hearing and you say,
The hearing,
"I'm on site visit right now."
Later on.
I've always
but what if
I've
they-
always continued it. So we're gonna meet the next time and then we're gonna go here and then we're gonna convene the hearing. Just so everybody's on the same page as to what's gonna happen at the,
No.
I've
He's
never
got a
done it
chance
on
to-
the spot, but I've had.
He's gonna
I've-
move the cars though.
well, maybe. I mean,
So we've got people who run machinery and stuff and the one on Gorsuch Road, where the guy had all the equipment in the back and.
the neighbors don't, the neighbors don't,
Neighbors
can't
are all
provide that.
bitching like hell.
Are
Okay.
they here? Again, can I ask them questions as to whether or not how many cars he's got on the lot?
Okay.
I mean, you just gotta get it somehow, but you
Well,
can definitely do a
but
site
know-
visit.
But they're doing it.
Yeah.
Other things is, there's a ton of equipment there. You've seen it, especially.
Yeah.
Specialty equipment. You drive by it every day and you say, no, there's not.
Well, I think that goes to, I would remind them they're under oath, right? And that goes to credibility.
Okay.
That goes to credibility.
Well, would you,
And plus you all, you can
for
do,
the fact that you know personally from observation that that is not true?
I think my preference would be to try to elicit it some other way.
Yeah, I was gonna say, because you don't want to get, he said, she said.
Correct.
That's
Correct.
Yeah.
But that's the thing, when I'm sitting here on.
But you can't take what you know out of the back. I mean, and that goes for any judge, right? I mean, a judge is going to have a certain level of knowledge. And to ask that, I mean, to say that you can't, I mean, that's not human nature.
That just goes to the deliberation
Correct,
process.
correct.
But that's where you can have that deliberation if
I
you
think
think
that's
it's
good.
relevant
Yeah.
to have it, to do it in discussion.
Well, and we
versus
had a
saying,
case with the guy with his car thing just burned down.
Right,
I mean, we're all driving by his place. We
Right.
all know he's in violation. But he's lying and saying he's not.
right.
Yeah.
No.
But that's where you ask the zoning inspector. I mean, my guess if it's a problem property, the zoning inspector is going to know that, so try to elicit from some, but you can't do a site visit. I just want you to know that as well. So do the, on the use variance, there is no, courts use different language in terms of your standard. And it's really only one standard.
What page are you on?
I'm on my cheat sheet, I'm on page 7, but I may not have the same version as you. I,
Must be close.
um,
No, that's it. Number three dot.
I printed what you sent.
yeah, I've got all my notes probably on an old version, so I
Oh,
don't
okay.
because we
I
update
see
this when
use
the law
variance, yeah.
changes.
But the topic is use variance.
Yeah.
Okay,
And then there's going to be, yep. So 3B,
yeah,
there's, kind of 3 different
yeah.
versions. Like I like number 2, B2.
Mhm.
Does the variance result from conditions unique to the property question and not a result of actions by the property owner? This is what we often refer to as a self-imposed hardship. That's the test. And if you don't meet it, thumbs down. It's as simple as that, because being able to use your property, the use of property, and the reason this test is so stringent is because using your property in a way that's not permitted by the code will have a substantial impact on neighboring properties. So there's an extra level of scrutiny. What's fascinating is that used to be prior to the 1986 Supreme Court case in Duncan v. Midfield. That used to be the test for every single variance. And the Supreme Court said, wait a minute, time out, guys. Mrs. Griggs is only requesting a 1-foot variance into the side yard because she wants to make her deck a little bit bigger. So they came up with two different tests, one for a use variance, one for an area variance. And the Duncan v. Middlefield is, when you read the statute, it is a unnecessary hardship is what the statute calls it. And that's the standard for a use variance. Supreme Court basically rewrote the law. So if you ever get a use variance, pull this out. Number 2 there, 3B2, that's the standard. And I'm telling you, 99% of the time, you should never grant it. So conducting the hearing. We've kind of got a sample hearing format laid out there for you. I mean, you sounds like you guys know what you're doing. You swear everybody in. Mass swearing in is okay as well. Just if I come to the podium, say, have you been sworn in? Yes, I have. You may proceed. Just double check in case you get some scragglers coming in late that weren't. I have allowed all persons to testify there. once again, we've kind of talked about that already. If you want to try to determine who has standing, you don't have to let everybody speak. You can also basically have a rule that says if you don't have standing, you're limited to 5 minutes. You can do that as well. But be careful, right? You better be sure. If you make a mistake, it's going to come back to haunt you, or it may come back to haunt you. Do not establish time limits for testimony. So once again, if I have standing, don't tell me I have 10 minutes. Now my testimony has to be relevant. So I had a guy one time that just started reading the Communist Manifesto. It was actually in Delaware County. It was in Berkshire Township years ago.
Oh, gosh.
And so they looked at me and I shut them down. You know, I told him to show up to the trustees meeting if you want to read the Communist Manifesto. Cross-examination. If I have standing or I'm the applicant, I have the ability to cross-examine witnesses.
Really?
Yes.
That's cool.
Yep. Most of the time you don't see it or people just don't know about it. More often than not, it's the attorneys. So the one example I gave of everybody having an attorney, it lasted forever. Because the poor zoning inspector, she got cross-examined by the HOA attorney, the applicant's attorney, the next door neighbor attorney, and we had to you have to allow for it. Once again, same thing, just like you see on TV, you can't badger witnesses. You can't try to intimidate them. There is some level of decorum there that the chair and the BZA can exercise.
Right.
But you have
Judy.
to allow for it. And so the reason you have to allow for it is because when you render your decision, your goal is to, if somebody wants to appeal your decision, your goal is to confine the judge to your transcript that you created. But the statute says if my transcript is incomplete, so if I don't have a court reporter or I can't transcribe this meeting, the appealing party was not permitted to testify, to offer evidence, or to cross-examine. Testimony was not given under oath. The appealing party was refused the opportunity to issue a subpoena. You have subpoena power.
Right.
Or the BZA did not render conclusions of fact or basically support their decision. If I don't do those things, the statute says that if I appeal your decision, I can ask the court to open up the record and I can offer additional evidence at the court. So in other words, I'm getting a second bite at the apple. If I did a lousy job here, I now know what I need to work on at the court. So that's why we tell you, that's why you have to swear people in. That's why you have to allow for cross-examination. Is because your
You've
job.
had your day in court, so to speak, right here, and the record should bear that out.
Right. So a judge has to give deference to your decision.
Yeah.
That's the goal.
Yeah, we gave them all the opportunities.
Correct.
So do you have to offer them cross-examination? Is that something they need to know?
No. No.
So they ask
No.
for it, you're gonna allow.
Yes.
Do they have, what's their timeline to file against us? 30 days?
So yes, 30 days. So that gets tricky as to when that 30-day runs.
The day they see the letter.
Typically, but courts are all over the place.
I thought particularly when they send the letter of our decision to the applicant, our decision, that starts the clock at 30 days there.
That's typically the case, but there are some courts out there that run it upon the approval of the meeting minutes.
Hmm.
Because that's when you approved your decision. So, but I'd probably say 90% of the time, it's going to run from the date that you provide the letter to them. So I'm comfortable running it then, but once again, courts are going to err on the, they're going to give deference, to, somebody appealing your decision. So that 30-day window, sometimes I mean, those are legal arguments that people make. Because I've definitely had clients that have sent the letter and then the board approves the meeting minutes and we're arguing in court, is it the letter or is it when the board approves the meeting minutes?
Okay.
So, but I don't necessarily
So a
disagree.
good reason to be prompt in approving your minutes.
Yes. Yep. Yep.
Okay.
The other thing to remember is the burden of proof is always on the applicant. Right? So they have to, and I get this question all the time. I mean, um, you know, some of our clients list the Duncan B. Middlefield factors actually in their application.
Hmm.
And they require a narrative statement by the applicant to fill it out. And sometimes the applicant will draw a line or put not applicable. And is it my job as a BZA member to elicit that testimony from them? And I'm just being practical, and I tell my clients, yes. Really, it's not. I mean, burden of proof is on them to prove it, but
But you just
as
try-
much as you're lay people, they are as well.
You're trying to make it clean as possible.
Correct.
Question for Mike.
Yeah.
Application, we could put that tonight for the excavating company versus, or concrete company, whatever he wants to call himself.
Okay.
You think the neighbors will be,
Careful
Here.
there. But we
Not
should,
here.
we should probably not talk about.
We're
that.
on, we're being
Yeah.
recorded.
We shouldn't talk about it.
okay.
Yeah.
I have no opinion.
Very good.
Appropriate evidence, which I know I mentioned earlier, and you think about a lot of times, particularly with adjoining property owners, what they're offering, it's typically opinion. So if you know your decision is going to be appealed, so if I'm here arguing that if this person builds whatever they're requesting, it's going to decrease the property value, my property. That's speculative. I would not base my decision on that testimony. But let's say I walk in with a certified appraisal or something from a certified appraiser
Right.
that states it will, that you can.
Mhm.
One of the best BZA hearings I've ever seen conducted was by FedEx. So FedEx, this particular township as a conditional use permit, treated regional transportation facilities as a conditional use. So distribution facility, FedEx came in, applied for the conditional use permit. And I had everybody, all the residents, traffic, noise, pollution, light, you name it, property values. And not one of them submitted a shred of evidence. And sure enough, FedEx walked in with expert studies on all that stuff, with the experts there. And when I'm in private deliberations with my client, I'm like, well, I don't know really what to tell you. I mean, they haven't offered they haven't offered a shred of evidence. The neighbors haven't. And here you are with a stack of studies this tall
To the contrary.
to the contrary. So that just goes to that's more of kind of an extreme example. But I had one for a conditional use permit for a self-storage facility. And the lady behind and her neighbors, they actually hired a appraiser who did a study and showed that it was an decrease. So that's what I'm talking about.
Yeah.
Just a couple other two more things. Race judicata, fancy legal word. At some point in time, your decisions have to be final. So if I render a decision and deny an application and it's not appeal, I can't come back in and file the exact same application again. I'm done. Unless I show a substantial change in circumstances. And so what that means is typically it's got to be something significant from what I previously applied for. So that same 20% rule that I talked about earlier as to whether it's substantial or not, that's typically what courts will look at as well. So maybe I'm getting a variance for parking spaces and you deny me. I probably have to come back in and show that it's somehow some modification to my application that's at least 20%.
Improve.
That could go for square footage, that could go for whatever. So you don't have to keep hearing the same thing over and over. The last kind of oddball legal theory is reconsideration. So you have the right to reconsider any decision you make until the appeal period runs, which is 30 days, or somebody files an appeal. So let's say I deny an application and a property owner says, I have additional evidence. I would like to submit. I would like you to reconsider your decision. You can if you want to. I'm not saying that you have to, but you can. It's rare. Let's say I have.
But I would guess if you saw that evidence was significant, then all you're really doing is if you say no to reconsideration is giving them a path to the court.
Not necessarily.
No?
No.
I mean,
He had a
it
right.
seemed like it's a common sense.
If he had a right, he had a right to present the evidence.
Yeah.
So he's waived it. I think the other situation.
Because I'm thinking in that case, something new came to light that perhaps legitimately that didn't exist at the time.
Well, that's the reason that they're asking for the reconsideration.
That's what I mean.
But I don't think that's in and of itself, that's not grounds for a judge to overturn your decision.
No, but it might be a reasonable reason to open it back up again.
Absolutely. Absolutely. The other situation I've seen it is where there's 3 members and an application gets denied. I've actually had a board member who wasn't there ask the board to reconsider the application. Until they have, maybe it's a full board. And that was the exact fact pattern and it flipped, the vote flipped. So just be aware of it.
Yeah.
Oddball situation, if it ever comes up.
Okay.
And then the last thing is ethics. That you guys are, as officials of the township, you're subject to the ethics laws. So I cannot sit as a BZA member on, obviously, I mean, this is common sense, my own application, an application of a business associate, or a family member's application. And family is anybody who lives with me, kids, spouse, parents, and siblings. So if any one of those people have filed an application, you recuse yourself. And you can't take bribes.
But with that revelation, do we have to give it back? I'm just kidding.
Yeah. And so if you have a question about whether or not you have a conflict, I'd get with staff gets with prosecutor, and only you can recuse yourself. Nobody else can make you do it. So, you have no idea how many arguments I've had with clients and where I just simply say, I don't care what you do. It's not my neck.
Right.
So,
I had that. My father had a business, we lived in the same house anyways. And we was doing business with the person that brought an application in, and I said, since we do business together, I just recused myself and
Perfect.
left the room.
yep, that's perfect.
You know,
So,
it's hard, especially in township, because it's like the pizza place, they all live there to eat. Now he's
Yeah.
coming with an application for a sign.
Yeah.
You can't really say.
and people, I get that question all the time. Well, it's my buddy.
But
And that's not illegal. That's not an Ohio ethics violation. But if you don't feel that you're able to render a unbiased opinion or judgment, then that's okay. Recuse yourself as well. But that's up to you. I mean, you're not required to do it, but it does get difficult. I agree.
Yeah.
Because some of my friends, I would give them the benefit of the doubt. Most of them.
Okay,
So that's the scuttlebutt.
that's good. No, it's useful.
It's very good.
Very practical manner. Thank you.
Yeah, thank you for doing this. We appreciate it. I learned a lot.
So
It was enlightening.
so there is a bill pending right now that addresses what you want. There's no 200 feet in the statute because I just checked it. But there is a bill that defines like party of interest and aggrieved party that requires townships to send those notices out. It actually codifies it. I don't know where it's going to go. It does some other things so your decision time frame. So you're not required to decide an application that night. Do you all know that?
Mhm.
Right? How long do you know? I don't think your code dictates your resolution.
When I did the dog triage thing, we had three hearings.
Right.
Three parts of the hearing.
But let's say I close the hearing. I just closed the hearing.
We never closed it. We adjourned it to time certain place.
So you have the right, if you've heard everything, and let's say, you know what, we're done, we've got enough testimony, but we want to give Vince and the prosecutor's office time to write a formal opinion for us. You can close your hearing.
Good.
Right? So the statute, and I checked your zoning resolution and it doesn't contain a time frame. The statute doesn't say you have to render a decision within a certain period of time.
Right, right.
What I tell people is it's
Collect the
reasonable.
Evidence, and then we might
So I've done it for
just adjourn it till we get time to make.
the FedEx case that so we adjourned after we held multiple hearings, continued them until after the fourth one, we'd had enough. We said we're going to close the hearing, right? And then we're going to render a decision at a future meeting. I wrote a 13-page decision on that case. And it was at the next regularly scheduled BZA meeting, their regular business meeting. An item showed up decision on FedEx conditional use permit. And they rendered the decision that night. You can do that. So
Put a notice out for that? Or does it just need to
No.
be on your agenda?
nope, it just needs to be on your agenda.
Anybody was interested at the first meeting, but no, it was.
It was continued, yeah.
You don't, no,
Does that require reopening the hearing?
Where you don't continue it?
no, the hearing's closed.
The hearing's closed.
Oh, the
Hearing is closed.
You haven't
The
made a
decision
decision.
comes
Right.
post the hearing.
Correct. Now,
Decision post.
a lot of times my client will say, we're closing the hearing at the next because it's typically 30 days away. Most of my clients will do it within 30 days. At the next regular meeting of the Board of Zoning Appeals, we are going to render a decision. It's not a continuance of the hearing. It's just that you're announcing when the decision could be
It
made.
allows individuals some soak time on what they've heard. It
Yeah.
doesn't allow discussion amongst.
And so you can work with the prosecutor's office on writing that decision, review that decision, and that decision could be circulated. And then you can run, if it's in writing, you just basically make a motion to adopt the resolution approving the conditional use permit.
That's a good idea, guys,
Yeah,
that you could have the prosecutor's office help you write the decision.
Only on the really hairy cases.
right.
Yeah,
Vince will kill me if you guys are.
But,
Know who said that?
yeah,
no, but I'm saying on some of the hairy ones.
I could
yeah.
see that. Yes.
Yeah, it's beneficial.
Okay.
So we've got more leeway on a lot of things he said than we originally thought we did.
Yeah. So that's
Going into, you know,
Discussion.
that same legislation now imposes a 30-day shot clock. So you may need to update your training if that thing goes through, because it's going to tweak a lot of different things, but just food for thought.
okay.
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 But we can flip back that, back to just the contiguous and next two properties now and get rid of our 200-foot buffer.
I think 200 feet is fine, quite frankly, because it's small enough.
Yeah, because most of our we're not a
Well,
high
rural.
density area.
Yeah, we're not including five
like-
people. Yeah.
Like when Orange Township rewrote their code, we had them take out that distance requirement because people were applying and it was sure enough a single family lot, and right behind it was a condominium complex,
Oh,
and like they were sending out 200 notices to people.
Yeah.
The 200 feet is fine. I'm just telling you that even though I may not be contiguous or adjacent, if I still get a notice, I would not limit that person's ability to testify
I
about gotten a
agree.
notice.
Yeah. Okay. Very good.
good.
Okay.
Good. That's good stuff.
All right. Well, look, we will close that portion of our meeting.
Next one, did you?
Having said that, is there any other new business? Any other new business? Mike, do we have any report from you? Okay. Having said that, do I hear a motion to adjourn?
Our meeting date.
Oh, well, the meeting date will be April 20th at 7 o'clock.
Thanks, guy. Appreciate it.
Thank you.
Thank you.
Pete, thanks.
I'll make a motion to adjourn.
I second it.
All in favor?
Aye.
Very good. All right.